of legal action, advocacy, legislative action as well to save the last 10 or less percent of the once magnificent old-growth forests in the Pacific Northwest. It was a masterful piece of lawyering. It was a very well orchestrated, thought through, as I say, campaign. It was not just ad hoc lawsuits. It was a strategic move to force the recognition of the values of these forests. And Vic had a great team around him, but it was really Vic's leadership that brought that really tremendous victory home. Today, there's still problems in the Pacific Northwest, to be sure, but 80% of the logging that was going on has been terminated as a result of Vic's and company's efforts. From there, he went on to actually serve as president of Earth Justice, and even went through the process of renaming Sierra Club Legal Defense Fund. Served in that capacity for a number of years, expanded the reach of Earth Justice, increased the staff, increased its presence in different parts of the country, including a very strong presence in Washington, D.C., to defend the laws that Earth Justice uses to enforce environmental requirements. Had a great run as president of Earth Justice, and then left to form a firm in San Francisco, Sher and Leff, focused on toxic tort litigation, and a remarkable string of victories there that Vic is going to tell you more about. So he's a Stanford Law grad, he's a San Franciscan, I think, forever, and he's a wonderful inspiration, and he's got some great war stories which you're about to hear. So Vic, take it on.
Thanks, Pat. Pat leaves, I understand that he was introducing me, but he left out what was really an inspiration to me during the slotted out proceedings. Pat was brought in at one point. Let me just set the context very briefly here. Our set of lawsuits was a campaign, and it was conceived up front. And the gist of it, the core of it, was that there had been a change in scientific thinking about what it took to preserve species viability over large landscapes. And the agencies charged with, on the one hand, protecting and managing the land, the Forest Service and the BLM, and on the other hand, the species, the Fish and Wildlife Service, had very consistently and persistently ignored what was emerging as a scientific consensus. And so we brought lawsuits against the Forest Service under the National Environmental Policy Act and the National Forest Management Act, against the Fish and Wildlife Service under the Endangered Species Act, against the BLM under its governing statute and NEPA, and against all of them under basically every possible permutation of species. I think at one point, when Pat and I first met, we had lawsuits pending in 4 different federal district courts in Oregon and Washington, 3 appeals pending simultaneously in the Ninth Circuit, and 1 case that went up to the U.S. Supreme Court. And Pat was brought in when the Fish and Wildlife Service finally called foul on the Bureau of Land Management, which wanted to sell timber in habitat where the Fish and Wildlife Service had determined that sales would cause jeopardy to the spotted owl. Pat was brought in as special counsel to the Fish and Wildlife Service in a what was technically a proceeding in front of an administrative law judge to create a record that would go up to a cabinet-level committee with the power to exempt BLM's conduct from the Endangered Species Act. That committee is known as the God Squad. And if it hadn't been so sad, it might have been funny. But this was a situation in which among other things, the solicitor of the Department of Interior was simultaneously advising the administrative law judge and acting as the boss of the head lawyers for both the Bureau of Land Management and the Fish and Wildlife Service, who were diametrically opposed in the proceeding. I represented the public interest interveners, well, the environmental group interveners. There was also timber community interveners that came in on the other side. And Pat ultimately got caught in the crossfire between the different agencies and did a spectacular and admirable resignation because he had been put in an untenable situation. One of the things I actually remember most about, or best about those proceedings was that our offices were together in a temporary office space that we had while this was going on in Portland, Oregon. And during the day, we were in a federal courthouse that was surrounded by timber trucks most of the time. But in the evenings, we would retire to these offices and plot frequently together how we were going to handle the upcoming proceedings. And there was a guy who was a special Fish and Wildlife Service agent who was in charge of security for the proceedings, Tom Riley. And Tom had been, in his prior life, he had played linebacker in the NFL. In fact, it turned out that he was the first player ever to tackle O.J. Simpson in a professional game. Some of you may know who O.J. was. Before he murdered his celebrity wife, he was a heck of a football player. So Tom he was a big guy. He had his linebacker size stare, and I think he was a little sweet on one of the lawyers who was working for Pat, and she on him. And so he would come by and give us scuttle about the administrative law judge and his wife and all that sort of stuff. One day, the lawyer for one of the timber industry groups, a guy named Perry Penley III, was a colleague of a guy named James Watt. Anyway, he and I, it's fair to say, we're not friends. And we had an exchange in front of the judge that the judge just would not stop. And neither of us would stop. And we went on, and I was ticked at Perry, and he had me. And we went, and then I got really angry at the judge for not cutting us off and letting us go on and on and on. And finally, we both ran out of things to say, and the judge said, well, why don't we take a break? And I went storming out to get a soda or something. There was Tom standing by the exit to the courtroom. And as I walked by him, he said, you want to borrow this? He had a gun under here. And I said, Tom, you don't have enough bullets in that for what I have in mind. He said, no problem. Well, you are any of you lawyers already? And I'm going to orient my talk mostly towards law students, but I think that these are generally applicable. I had a professor in law school who was very old school. You're very fortunate to be at a law school that is not old school. But his attitude was, which he held very strongly and tried to get us to adopt, was that a lawyer who took on cases for causes that were near and dear to the lawyer's heart was doing a disservice to his clients. His thesis was that a lawyer who cared about the cause and the case was like a lawyer who represented himself, and that what clients needed were disinterested legal technicians who could bring an objective eye to the proceedings. What a crock. And so let me be very upfront about my bias. I think that there is good and evil in the world, and that the courts are an important forum where battles between the two take place. And that lawyers who have the opportunity to take sides and who work on the side that they believe in are fulfilling the highest calling in the legal profession. And I will tell you that when you care about a case, you work that much harder. You find the extra expert. You read the extra cases. You spend the extra time honing the briefs. And the losses hurt more because you care, because they're important. But being involved in the good fight is a way of spending a professional career that is extraordinarily satisfying. And I want to talk about some of the ways, some of the steps that you can take to make it work, that you can be involved in good work on an ongoing basis and pay the bills at the same time. The good news is, to start off with, that environmental litigation, and by that I'm using the term to mean litigation on behalf of the environment, is a growth business. And this is a little bit of the litigator's schizophrenia. Oh, you mean you have a toxic chemical in your drinking water supply that's going to cost your town zillions of dollars to pay for that you don't have? That's great! Sucks for you, but it's great for the case. But the truth is that problems in the environment, whether you're talking about species on public lands or contamination in communities or the pressures of overpopulation and overutilization of resources, are getting worse. The problems are getting worse and more numerous. They're not getting better. And the law is one of the few level playing field opportunities for the environment's voice to be heard. Thinking about what I wish I had known as I was coming out of law school, and by the way, I did not know that I wanted to do environmental litigation. Let me offer you 7 principles. First, the most important thing you can do is learn your way around cases, how to litigate a case. It's far more important that you understand the dynamics of a lawsuit and how to think about mustering proof and legal theories, and present them in court, and conduct discovery, bring motions, and deal with the prospect of a trial and resolution, than it is, I say this in the presence of law professors, than it is to really know what the rules are as you enter. When you get into, that is, you can learn the substantive law to fit your dispute. And what you will find is that when you get involved in particular cases that involve particular legal issues, you will dig down into them in a way and in a depth that a survey course and even an advanced course in law school can never help you, can never prepare you for. And so the more important thing to do is to learn how to do that. And because you'll learn the substantive law to fit your issues. The second principle, and I get asked about this a lot, is follow your heart. Don't fall into the trap of thinking that you're going to go learn about environmental law by representing polluters. And this is for 2 reasons. First, you'll be unhappy while you're doing that. And second, the truth is that the plaintiff's bar and the defense bar not only disagree about the law, they have completely different worldviews. Everything about how they look at a case, from what are the significant facts to what is the burden of proof to what is adequate to plead as a legal claim, is different. And I'm sorry, but learning the defense way of thinking about it will not prepare you adequately as a plaintiff's lawyer. Now, I don't mean to be dismissive of people who are brethren and sisters in the profession who are representing defendants. I can articulate as well as anyone that it's a process that requires representation on both sides. I had a conversation in the middle of a deposition one day with a woman who represents a large oil company. And we had just settled a piece of the case with 2 other large oil companies. And word of the settlement had gotten around, and their lawyers had disappeared. And this woman makes a comment to the room of, if I were in it for the money, I'd be on the plaintiff's side. I said, without thinking about it, I sometimes do. I said, so you went to work for oil companies out of principle? And this is a comment which was unwise on my part. Because the truth was we were litigating against each other for a decade, and she never forgave me for it. So I had to beat up her client. We had to settle cases. Another way of thinking of it is this. We had a big trial in 2009 where I represented the city of New York against Exxon. And my then 3-year-old daughter commented one night at dinner in the hotel that we were staying in, said, "Daddy, I think Exxon and the Wicked Witch of the West would be good friends." And that was a babe. The third principle is be realistic about landing a job with one of the big national environmental law firms. Earth Justice and others have very few positions. There are many, many applicants for them, and they almost never take anybody right out of law school. The lawyers that they do hire have either been in practice for a while and developed their own track record on environmental issues that they bring to the organization, which is actually how I got into it, or they've at least done several years of clerkships. Which means that if that remains your goal, if what you want to do is end up doing environmental litigation for a nonprofit, you need to develop a strategy for doing that goes beyond simply your academic performance in law school. And it entails building relationships with people at those firms and injecting yourself to the extent that you can in their work, or building a body of work on your own, which is what I'm going to talk about next, that you can then bring to them and say, "See, I'm already doing good stuff here. When you have an opening, you should hire me." And there is, the corollary to this, is that there is lots you can do in private practice on your own, even as a junior lawyer. And I'll come back to that in a few moments. But the fourth principle, which is related to all this, is you've got to know your limits. You've got to know your limits. Environmental litigation always gores someone's ox. And if you're not careful, on the one hand, you're doing something good. You can gauge sort of the magnitude of what you're doing by the force of the response. But if you don't watch out, you're going to find yourself not only swamped in a lawsuit that you can't handle, but you're going to find the law change, and thereby depriving you, not just you, but others of the right to enforce it. So know your limits. Know your skill set. If you've never had a trial, understand that a trial is a different experience from anything else. If you've never conducted discovery of experts, understand that that's something that needs to be learned how to do. And so look around for help. There's a lot you can do to educate yourself, but the best way to do it is to attach yourself to somebody who already knows how to do it, whether that means going to a law firm, finding a senior lawyer, somebody, or even a retired lawyer who's willing to help you out. Know your limitations in terms of money. Environmental lawsuits can be managed in a very cost-effective way if you're careful about what kind of case it is. And so be sensitive that if you're getting in a kind of case that involves a lot of, for example, expert testimony, that those costs can quickly spiral out of control. The New York City case that I mentioned, $5 million in expert costs on our side. And it's still up on appeal, so we still haven't been paid. And finally, if you run up against a case that all of your skill and training and experience and your stomach tells you is a great case, but that you don't have the skills or the resources to handle, get help. And if you can't get the right kind of help, make the hard choice to walk away from it. You talk about mortgages getting underwater. If a lawyer gets into a case that's over their head, then there's some drowning that can happen. A really good, actually, a very accessible and popularized example of this is A Civil Action by Jonathan Harr, a movie that had John Travolta in it. Pat had some. Pat was a Vermont EPA regulator at the time, and tried to get the plaintiff's lawyer, Jan Schlickman, to just slow down and let the EPA make some findings, which would have killed his case. And he didn't, and the result was that he lost a fortune and lost the case, and committed ethical violations. He didn't convey a $25 million settlement offer to his clients, which is, that's not even a close call. So I used to wonder why Jonathan Harr, who's a brilliant writer, hadn't chosen as a subject somebody who actually knew how to do a case like that. It wasn't until I was a little older that I understood that it wouldn't have been nearly as an interesting story. But, that was a case that I think could and should have been handled differently to a different result. Principle number 5. You got to get the cases. Which reminds me of a joke that Steve Martin used to tell, which is, how do you not pay taxes on $1 million? Well, first you get $1 million. And so, it's like the old story about restaurants. It's all location, location, location. If you don't have access to the cases, you can't prosecute the cases, you can't choose how to do it, you can't win them, you also can't lose them, of course. But how you build a practice is something that to think about, and there's some definite things you can do to make it happen. When when I graduated from law school, I had debt, and I didn't know that I wanted to do environmental law. And I went to work for a commercial litigation firm, and I spent a couple of years there doing securities fraud, investment fraud, and partnership dissolution lawsuits. And I was not very interested in the transfer of money from one wealthy person to another, but I was really interested in how the case worked. And we did some pro bono fair housing litigation, which got my foot in the door doing something outside of the commercial litigation area that I was much more interested in. And after 2 years, 2 other associates who were equally ignorant of how to practice law and I started our own firm. And it turned out that the fair housing cases were a significant source of ongoing money for us. We figured out how to set them up on a way that we could run them through and get resolutions for our clients. And then we thought, gosh, doing some environmental stuff would be kind of cool too. So we went and visited with the local Rick Justice and Sierra Club Legal Defense Fund, then believing, as many people did, that they were the Sierra Club's lawyers. And we went to visit them, and we said, do you have any cases where we can work with you or help you out? And they said, we really don't need you on our cases, but look, we've got these boxes of files of people asking for help. Would you look through them for us and see if there's anything to be done? And I got into a series of cases involving land use issues on the California coast, where either hotels were proposed right on the beach, or there was one that I did where there was a very large number of luxury home units proposed in what was supposed to be an agricultural preserve area. And so I took on those cases, and they were kind of fun. And I got a real education in being home court, because the luxury home development case, the lawyer representing the developer was a former county counsel, and he appeared in front of the judge innumerable times. And I was, it was my first time in almost any courtroom, but it was my first time in this judge's courtroom. And so we pushed it as hard as we could. We lost at the trial court level, and so we took an appeal to try and stop the bulldozers that were happening. And right around that time, I started getting phone calls. I don't know how he tracked me down, but it was a guy with the Trust for Public Lands. And he said, nobody can ever know about our conversations, so if you ever say anything about it, I'll have to kill you. And he said, if you can get an injunction, we're negotiating an alternative option to buy the property and sell it to the state for parkland. I said, really? You can do that? And he said, yeah, we're working on it, but you got to get the injunction, because otherwise they'll go ahead with the luxury home development. Court of Appeal issued the injunction, and sure enough, within days, They had an option to purchase the property that they exercised, and it's now what's known as the Cascade Ranch State Park. And what's interesting about this is if you look at the history as told by the state of California for this park, there's no mention of the litigation. But there's no question that we wouldn't have that state park but for the lawsuit. This kind of case, these land use cases, were perfect for a young lawyer. They were administrative record cases. They were summary judgment cases. The experts were lined up as volunteers for the citizens group. And the citizen group was relatively sophisticated and knowledgeable. And best of all, under California law, there was a fee paid by the defendant at the end of the case. So there I was. I was about 5 years out of law school. I was doing this mix of cases. And then I had the case that made me want to do nothing but environmental law the rest of my life in my office. And this was the case in Humboldt County. I represented a couple of organic apple growers, a couple who were organic apple growers. And the state of California had detected in Humboldt County a few fruit flies that were relatives of the medfly. They were called the apple maggot fruit flies. And as a result of the commercial, mainstream, non-organic apple growers persuaded the state to spray a derivative of German nerve gas on every apple tree, crabapple tree, hawthorn tree, or bush in 6 counties. And my clients didn't have any money, but they were going to lose their organic certification if they got sprayed. So I took on the case because there wasn't any kind of environmental documentation at all. And I thought that there should have been an environmental, under California state law, called an environmental impact report. And I tracked down a toxicologist who had been the chief toxicologist for the state of California under Jerry Brown's first governorship. And he did an analysis that said that basically if a 7-year-old child weighing 40 pounds played for 5 minutes under one of these trees that had been sprayed to drip, he or she would receive 12 times the allowable lifetime dosage of this organophosphate nerve gas. We tracked down in upstate New York the world's leading expert on the apple maggot fruit fly, who told us that using this chemical would suppress but not eradicate the pest, and that there was an equally effective, albeit more labor-intensive alternative of hanging gold or red sticky globes treated with a pheromone that would, in the orchards, that would attract the flies that would reduce the population to just about the same levels. And armed with this evidence, we went in and moved for an injunction. We also decided that because one of the statutory criteria for requiring an environmental impact report was the existence of public controversy, that we should get statements from citizens, doctors, nurses, and people around the community. And so we went in, we had a form declaration, and then we enlisted the help of a local citizen group that went around, and they gathered hundreds of these declarations, and then we split them up between mothers and others and doctors and nurses and all that. Put them in big binders and submitted them to the court. And we walked in. Now, bear in mind, again, in another situation, no money coming to me or my co-counsel on this, but we got to stay in people's homes and whatever out-of-pocket costs there were largely covered. In the middle of this, though, we got contacted by a lawyer who said that he represented certain interests that really wanted the state spray program stopped. I said, which state spray program stop. He said, any state spray program stop. And he said, we are willing to fund your fees plus a little more, to help support this. And it turned out that this guy was a conduit for the black market marijuana crop growers in the Redwood Forest in California. It wasn't even hard to say no to it, but it was, it was very bizarre. We walked into the courtroom with the state court judge in Northern California, and the first thing that happened was that I saw that the guy had a picture of himself, the judge had a picture of himself with Bobby Kennedy, and it turned out that he had been Kennedy's campaign manager in the local area the year that he was assassinated, 1968. And the second thing that happened was the judge had our stack of binders. Now, I thought that the only legally significant papers that we had submitted were the toxicology and the entomology expert reports. Judge turns to the lawyer for the state and says, is it true, sir, that your workers are telling citizens that Imidan, which is the name of the chemical, is as safe as soap? I looked at my co-counsel and I said, does it say that in there? He said, yeah. And the lawyer said, Beeble, Beeble, Beeble. And the judge said, I'm not telling you how I'm going to rule, but I want that to stop right now. So we had the injunction hearing. The judge issued the injunction. And I was hooked. I was a political philosophy major in college. I really had taken very little science. I had taken some history of science classes. I had taken some geology, rocks for jocks type classes. But I really enjoyed working with experts on the human health impacts and on the alternatives and learning about every aspect of the case. I have to admit, I loved the TV cameras when the injunction issued. A little bit of a media hound I discovered. And so when the Legal Defense Fund, Earth Justice, was looking for somebody to run the Seattle office, I threw my hat into the ring and got hired and got launched on this incredible spotted owl journey. I'm not going to talk about that other than to say that those kinds of cases required a major devotion of resources. I don't believe that lawyers in private practice could have handled them. They could have handled pieces of them, or maybe single lawsuits, but it required the full-time effort of a litigation team over many years, with for many years no financial return at all. And it's hard to imagine that the private bar could have done that. Which brings me to my sixth principle, which I want to introduce this way. William O. Douglas, who was the premier environmentalist on the Supreme Court, some would say the only true environmentalist ever on the Supreme Court, in his autobiography talks about the time that he went out riding on a horse in the Cascade Mountains. And they were walking down the slope, and all of a sudden he hears an enormous noise behind him. And he looks back, and there's a landslide, rocks coming down the mountainside. And he turns the horse and tries to get away, and the horse falls, and he's engulfed in it. The horse actually fell on William O. Douglas. The horse was largely unharmed. William O. Douglas broke every bone in his body. Or a lot of bones, anyway. Which brings to mind Congress. And what happens when you poke a powerful interest. One of the most important lessons from the spotted owl saga, and it's been replicated every time I've seen lawsuits attack the entrenched political and economic interest, was the strength of the reaction. We got our first minor injunction over spotted owls. It involved only a handful of timber sales on the National Forest in Washington in 1988, and Congress immediately responded with legislation that declared that the environmental documentation that we had relied on in our lawsuit was adequate for purposes of the laws that we were challenging. And that legislation or its successors stayed in place for almost 5 years. And it was impossible to litigate our cases. When the laws finally expired and we were able to get into court, we could prove our cases. But I was struck by how unprepared the environmental community was on the political front to respond to that kind of an action. I mean, we were courtroom lawyers. We weren't supposed to have to deal with that. So one of the innovations that I worked hard to put in place with Earth Justice, and that I'm proud to say is still in place, was to develop sophisticated political advocacy, which was offered as a service to clients along with litigation advocacy. I don't know if any of you have read Merchants of Doubt, which is it's a must-read. It's about how a small, powerful cadre, extraordinarily well-funded of scientists and PR people have taken on creating scientific doubt where there is none. So, for example, tobacco litigation, acid rain, hole in the ozone layer, and global warming have all been attacked as containing or embodying inadequate science or improper science or uncertain science. And it's become the template for industry attacks on environmental litigation. Principle number 7. This is the last one I want to spend a few minutes talking about. I think that environmental law, environmental litigation is evolving significantly. It's one of the strengths of environmental litigators that they bring creativity and originality to problems as they arise. But we're dealing, or I don't know if this is an and or a but, probably an and. I think we're in a little bit of a back to the future situation. For the last 40 years, since the early 1970s, environmental law has been synonymous with enforcement largely of federal statutory law, and in particular citizen suits under federal statutory law. And there's no question but that body of litigation has been tremendously important and effective in moving the environmental agenda. It is a sad fact that if you look at the dockets of the environmental groups, nonprofit environmental groups, and the dockets of cases brought by citizens groups, they are overwhelmingly suits against the federal government to enforce procedural requirements. And that most of the remedies, and this is inherent in the structure of suing the government under our separation of powers, most of the remedies are the courts declaring that conduct has been so arbitrary and capricious or not in compliance with procedures required by law as to violate the discretion vested in agencies. These lawsuits are not, frankly, about what is good or best or wisest for government action and policy. It's only whether the action taken is so egregious as to violate the irreducible minimum required by the procedures and the substance of the law. So it's really an astonishing thing how the government continues to screw up and that people continue to bring and win these lawsuits. But I think we're starting to see an evolution of litigation that focuses more directly on bad corporate behavior that leads to environmental bad results. And the chemical contamination cases that I've been part of, I think have been part of that. So let me very briefly tell you about structurally how these work. These are cases involving products that had gotten into drinking water that cities then use to deliver to their customers, to the public for drinking water. And they range from agricultural products like DDCP and trichloropropane, which were in products that were used to try and kill nematodes, bad microscopic organisms for agriculture. Or perchloroethylene, which was used, PCE, used by dry cleaners. and all of these are incredibly toxic, incredibly persistent, incredibly mobile in the environment. So they're released at a dry cleaning spot or by a farmer to fields, and they leach down, and then they migrate with the groundwater, and they get into drinking water supplies. Or MTBE, which is a gasoline additive intended to boost oxygen and make gasoline burn hotter. Also, an exquisite groundwater contaminant. And the innovation of our lawsuits was realizing that traditional legal and regulatory structures focus the cleanup remedy on the party that actually released or spilled or put the stuff into the environment. And if you're talking about dry cleaners or local gas stations or local farmers, first of all, they have no culpability. They were handling and applying the chemicals according to instructions in the way they always had handled stuff. And they, more importantly, when you're talking about a water treatment facility that costs millions or tens of millions of dollars, they're judgment-proof. They don't have anything close to the resources to pay off the judgment. So you have this whole regulatory structure under state and federal law, Superfund, RCRA, and Clean Water Act, Safe Drinking Water Act, and they don't provide remedies. Their only remedies are against the local polluters, and they don't provide remedies against the companies that actually made the decisions and formulated the product and profited from them and failed to tell anybody about the dangers, about which, by the way, they knew. So we treated these cases not as environmental contamination cases, but as defective product cases, and sued the manufacturers of gasoline refiners. And let me just take a moment to tell you a little bit about the MTBE cases. Some of you may know that the state of New Hampshire is in trial against Exxon as we speak over statewide contamination for MTBE. And until a little over a year ago, I was the lead outside lawyer for the state. MTBE, chemical name methyl tertiary butyl ether, but internal oil industry documents used to refer to it as most things biodegrade easier or major threat to better earnings. And the big rap on MTBE is that when it's released from a gasoline storage tank, and which basically all gasoline systems leak, it travels farther and faster than gasoline that does not contain MTBE. So this is a well-studied site in Southern California. The gas station is down in the lower right-hand corner. And that is what's known as the VTEX plume. This is the non-MTBE portion of the contamination. VTEX stands for benzene, toluene, xylene, and ethylbenzene. And they are toxic, but they are fossil fuel based. So if you leave them in the subsurface, their plumes over time stabilize. The bugs down there love them. They eat them, and the plumes biodegrade. Here's the MTBE plume at the same site. Whoa. So when we were trying the New York case, this was a graphic that we used a lot in California. When we tried the New York case, we were concerned that the jury would think, well, that's California, what about New York? So this one is a site in New York out on Long Island, the same sort of soils as we had in Queens. Gas station in the upper right. Here's the VTEX plume. It's 1,000 feet long, roughly. Not a small plume, okay? Here's the MTBE plume. So then, and by the way, did I mention that MTBE doesn't biodegrade, essentially? So unless it's extracted or diluted, the plumes are virtually permanent. So then we got into New Hampshire, which has fractured bedrock under systems. And at each step of the way, Exxon and the other oil companies argued that the earlier examples didn't apply. Well, California couldn't apply to New York couldn't apply to New Hampshire because New Hampshire has fractured bedrock, which means that the plumes are unpredictable. Well, yeah, they are. Watch this. Okay, here's the gas station. Here's the VTEX plume. And here's the MTBE plume. And those are the wells that were affected by that particular plume. So the gist of the lawsuit was not only that MTBE travels farther and faster, doesn't biodegrade. By the way, it has a very low taste and odor threshold, which means that people know that it's in the gas in their water at single-digit part per billion levels, and it's very expensive to remove. Well, the rest of the claim is that Exxon and other companies knew about it. So this is a 1984 memo. Exxon is just starting to consider using MTBE as a replacement for lead. Good thing to get lead out. They weren't thinking of it to boost octane. And this guy writes, subject use of MTBE in Exxon motor gasoline. We have ethical and environmental concerns that are not too well defined at this point. For example, possible leakage of storage system tanks into underground water systems of a gasoline compound that is soluble in water to a much greater extent. Well, the following year, there was a series of memos by another scientist which actually went to the decision maker, went to the executive in charge of it. She said, okay, as stated in our previous memos, MTBE in Exxon gasoline is of concern as an incremental environmental risk for 4 reasons. It travels farther and faster, it doesn't biodegrade, it's expensive to remove, and it's got an extremely low taste and odor threshold. As a result, we recommend that Exxon, from an environmental risk point of view, MTBE not be considered as an additive to Exxon gasolines on a blanket basis throughout the United States. Now, it turns out that gasoline from any given refiner gets commingled, and that if you go to your Citgo gas station on the corner or your Urban gas station on the corner, it has gasoline refined by every other refiner as well. And that's because they buy and trade it in wholesales, and they pipeline it, and they meld it, and they blend it. All of the major refiners in the 80s, when we were making this decision, knew that the gasoline would go into underground storage systems, 75% in the U.S., which were owned by mom and pops, and were notorious sieves. In fact, if you look at the underground storage tank gasoline regulations from the time, even EPA was saying, not about MTBE, nobody knew from MTBE, but they were saying we need to regulate this because mom and pops don't know what they're doing, and we have a huge leakage problem, and tanks are going to fail. So, did Exxon and the other companies warn anybody? No, they didn't. So this guy, Victor Dugan, was an Exxon executive who was designated during the court proceedings as the corporate representative about the decision making. And I asked him a series of questions when he testified in New York about, wasn't it true that Exxon had known, based on those earlier memos, that there was this incremental environmental risk for those 4 reasons? He said, yes, yes, yes. And I asked him, would you agree that if a company knows the dangers of its products, it has a duty to warn about those dangers? He said, yes. I asked him, would you agree that a company has the duty to warn those that handle the products and those who may be injured by it? He said, yes.
Objection calls for a legal conclusion.
Well, no, because Exxon's corporate policies embrace those kinds of disclosures and in language of duty. But yeah, right, duty is a legal conclusion. And your company provided no warnings to anybody about the increased risks of contamination and greater costs in connection with MTBE gasoline. Correct. Answer, yes. We also deposed this guy. This was great. He was the executive who actually made the decision to add MTBE to Exxon gasoline. And we asked him, at the time, Exxon made no effort to even inform station owners that MTBE was in the gas. Isn't that right? His answer, well, we didn't uninform. So these are examples of, unfortunately, this is a common tale. I mean, common in that it's common to all the different industries. And whether you're talking about the dry cleaning industry and solvents for that, or the agricultural industry, the large chemical companies that were developing these compounds for use, even when if you grant them the socially beneficial purpose, they knew of the risks and didn't tell anybody. And as a result, what we have are these enormous, what economists call externalities, the costs to the environment that the company avoided paying. So one of their big pitches for MTBE was, Well, it was a lot less expensive than alternatives like alcohol. So did you consider the cost of cleanup as kind of part of the cost? Did you consider the cost of water treatment? Did you consider the cost of upgrading tanks for all the bomb clocks? No. So the economics came out in the right way. The legal theories that we used in these cases were common law theories: negligence, nuisance, trespass, and defective product, both because of the cost-benefit analysis or risk-benefit analysis and because of the failure to warn. And every trial that we've had, the first one settled after the case, after we had a special verdict of the product. But the New York case, we got a substantial jury verdict. All right, I do want to leave a little bit of time, less time than I had hoped, but I did want to leave a little bit of time for questions. So let me just wrap up this one. The opportunities are there. They require you to be smart. They require you to have a sound head for business. They require you to be creative, and they require you to be persistent. But if what you want to do is environmental litigation to help the planet, the opportunities are there, and the world needs you. So I really encourage you to follow your hearts.
Time for some questions. Anybody like to ask one? Fire away.
I taught nuisance today, and there have been some developments in the Supreme Court that are kind of discouraging with respect to nuisance theories. I just wonder if you could offer your perspective in the kind of broadest sense of whether or not common law nuisance claims on behalf of the communities, homeowners, are a successful strategy.
They're one of the less successful strategies that we've had. It's interesting. The California courts have, when we started these cases, the law, the issue is this: a nuisance is an unreasonable interference with the comfortable use and enjoyment of property, or if it's a public nuisance, it's something that's basically inimical to the public good. And we thought that a company that launches its product willy-nilly, that physically invades the water of the community, fit that model pretty well. California courts have narrowed it with respect to manufacturer liability in a nuisance, that you have to show some form of direct participation, which can range from marketing to promote the product that misleadingly fails to do it. But you cannot just have a failure to warn, which is tortious, and we thought ought to cover it. The law in other states, for instance, in New York, the law was pretty favorable, but we got an odd finding from our New York jury. They found that there was not a private nuisance, but that there was a public nuisance, and that Exxon was liable for that, even though the city had suffered special injury. And when we asked them after the case why that was, they said they thought that it was just a more important problem than private nuisance. So they wanted to stay on and elevate. I have my personal. I am more enamored of trespass, because with trespass, the legal standard in most jurisdictions is was the actor or should the actor have been virtually certain that its product would end up in the property of the injured plaintiff. And there where you have, memos like the ones I showed you, where they say, if you put the stuff into the system, it's going to cause this incremental environmental risk by invading drinking water. It's hard to argue that they didn't actually know what was going to happen. So I like trespass because it involves physical invasion. But the product liability theories are a challenge, because frequently, now some chemicals you don't have this issue, but for example, DBCP, which was a miracle agricultural product, it was the only soil fumigant that could be applied to crops while they were in the ground. So you have a benefit to go on the risk-benefit equation side of things. Whereas if it's a failure to warn claim, then it doesn't matter if there was a benefit. What matters is that they didn't warn of the risks, which is actually where the New York jury came out on product liability.
And my question is, have you seen over time, or maybe as a result of your work, have you seen companies making different decisions or more conscientious decisions than they did in the 80s or 90s?
Well, as an environmentalist, that's really the goal. And I'm going to answer it in two ways. First, timber companies aren't logging old growth in the Pacific Northwest at the levels that they used to because of the lawsuits. And it's interesting that some histories talk about the evolution of the policy without realizing that the agencies were brought kicking and screaming along only through federal court injunctions. So that's behavior that changed because of the court actions. There's no question in my mind that MTBE is out of gasoline because of our lawsuits as well. And what you hope is that what you'll do is you'll inspire more careful conduct in the future as companies realize that if they screw up this way again, they're going to be held liable and have to pay enormous costs. But the caveat is, and those of you who met at the clinic earlier already heard me tell this story, we got a $105 million verdict. It was quite large, not just because it was $105 million, but because it only involved 5 out of about 50 wells in New York. They were a bellwether, a test case. And we were feeling pretty good about it when the verdict came down. And the next day, Bloomberg's Business Magazine ran an article that really got the case right. They described what was at issue. They quoted me correctly, which always happens, and they talked about it. And then, as a throwaway at the end, the article pointed out that $105 million was less than 2%. Less than 2% of Exxon's net quarterly current quarter profit. So, what that means is that lawsuit liability doesn't even warrant a footnote in their stockholder disclosures. So you wonder, and I mean this sincerely, you wonder what you have to do to become material to those kinds of corporate decisions. If they can really absorb it as the cost of doing business, then we haven't found the next generation that's going to be more meaningful yet, and we still have that as a chance.
That was terrific. Thanks a lot, Vic.